Hello everybody, welcome back. And today there is another video on EU law and taxation, and we are still talking about the EU fundamental freedoms and their impact on tax laws. And after having described the basics here, we have to focus a bit on what is a discrimination. So we are here in chapter 2. This will be now chapter 2.4. What is a discrimination? And that is a highly important topic for us. So if a discrimination on grounds of citizenship, nationality is forbidden, then it's naturally a core question for us how we can find out what a discrimination is and under which principles the European Court of Justice and other experts of EU law judge that rule. So the term has not been defined in the EU treaties themselves. So you have to find out what it means just by jurisdiction. So by interpreting the law according to the acknowledged methods of interpretation of legal texts. You remember we have spoken about these methods already in the beginning of the lecture and have brought forward that, in the area of EU law, the methods are sometimes weighted in a different way. But if we have to find out the sense of what a discrimination is by interpretation of the law, then in the end, where everything ends up is just how do we understand the text. And so what is a discrimination is in the final effect a matter of common sense. And you will see whenever you deal with the the jurisdiction of the European Court of Justice on discriminations, that is very often sheer common sense. And if one is willing to renounce on a very, very formalistic view, something which you sometimes have been trained to do under a national perspective, if you renounce on that and just use your common sense, it's easily possible to understand the red lines or the train of thought which lies behind the standing jurisdiction of the ECJ. Well, so let's have a look. Jurisdiction just says a discrimination is a more negative treatment of the person which is protected or who is protected by the rule in question than for another person. So a discrimination must be something negative. If you are preferred, that's a favor and that's not forbidden. A discrimination requires that the unequal treatment to your disadvantage happens under the same circumstances as in the other case, that the criterion on which the discrimination or distinction is based is a forbidden criterion, here in EU law mostly nationality, and that there is no justification which can be brought forward because a discrimination, a forbidden discrimination, is only one which cannot be justified. So a discrimination has always the notion of being unfair and illegitimate. Now let us try to comment these elements of the definition a bit more closely. A more negative treatment of the person protected, that means who is treated better, cannot claim to be discriminated. Then you get a favor, privilege. Yeah? So you can't complain. The only person who could complain is the other person who gets treated worse than you. But you, if you are better off, cannot complain. Under same circumstances, that's clear. If the circumstances are not the same, you cannot require equal treatment. For example, arresting one person but not arresting another person is not a discrimination if the first person committed a murder and the second person did not. This is just an adequate distinction which takes into account the completely different situation of the two people. So, on the grounds of a forbidden criterion, forbidden by the fundamental freedoms is only the discrimination of EU nationals on grounds of nationality. So, with regard to other criteria, the legislator remains free to decide. The distinction between people who murdered somebody and not is therefore not forbidden and remains fully allowed. That would be possible. By the way, in recent decades, there have been added some other criteria into EU legislation, sometimes on the level of directives, where, but only in certain areas of law, discriminations based on other criteria have also been forbidden. For example, discriminations on ground of sex, gender, and sexual orientation, I believe. There is even an explicit anti-discrimination rule in the EU treaty for which demands non-discrimination for wages and working conditions with regard to men and women. Forbidden is a discrimination on grounds of age, of race, ethnicity, religion, I believe, and some other criteria. But that depends on in which areas that non-discrimination is granted and where not. So whoever is interested in that should make himself or herself familiar with the underlying treaty rules and directives, and then look where such discriminations can be found. But in principle, the general logic applying to discriminations based on these criteria will be similar to the ones on the grounds of nationality. Well, and the last criterion, there must be no disjustification. Making a different treatment is not forbidden if either it has been explicitly allowed by an exception rule in the treaties, or if it is accepted by the European Court of Justice by something which is implicitly tolerated by the rules of the treaty, because the distinction is necessary due to compelling reasons, because underlying idea, otherwise the whole civilization would break down completely. You have already heard from me that you have that rule, fundamental freedoms also forbid restrictions, but implicitly some are tolerated. And the idea is, well, if there is something which necessarily must be regulated by a member state, and if you abolish that rule or renounce on it or do it in a different way, then a complete part of the legal system, which is necessary for the common benefit, breaks completely down and can't be replaced. So compelling reasons means compelling reasons. Okay, now let's go to the details. A more negative treatment than somebody else. Well, let's think about potential cases. Imagine that A, living in country 1, has to pay a higher tax on an income of 50,000 euro than to his country 1, then B, living in country 2, has to pay to country 2. So imagine you live in Germany, you have to pay 45% if you have a million, and if you live in, let's say, France, you probably have to pay higher taxes. Or if you live in Liechtenstein, you probably have to pay a far lower tax on the million. And now your question can be, are you discriminated here in Germany because you have to pay more than a taxpayer in Liechtenstein on the same income? And the answer is a clear no. Why? Well, you have to pay a different tax than somebody else, but the explanation is you are subjected to German law, and the other taxpayer is subjected to the law of Liechtenstein, which is, as you know, a country of the European Economic Area, so that discrimination is forbidden there too. Now, a discrimination means that one and the same deciding person, institution, or what else, treats people differently. If you have two different people which can form their own decisions, then it is clear that, for example, two states who have the right, no, which have the right, sorry, I always make that English grammar mistake. So if two states have the right to write their own laws still, then it's a natural consequence that the law in Germany, the law in France, and the law in Liechtenstein will be different, so that somebody living in Germany, somebody living in France, and somebody living in Liechtenstein will have to pay different tax rates on the same amount of income. That's simply the problem of different laws. So that's built in the system. You cannot reproach to the Germans their tax rate is too high. You could also say the Liechtenstein tax rate is too low. Or the French tax rate is the only viable one for the whole common market. They all should all adopt the French rate, but nobody is obliged to do so. So the only thing which you can do is ask if the legal behavior of one state constitutes a discrimination. The mere fact that the law of another state, if it were applicable, would lead to another result is no argument. A discrimination can only come from a state's own behavior. And so that would not be the case. Sometimes you will have to do that first test in principle. Do the problems or do the differences come from the application of different laws to the case? Laws of different states, okay? Then you cannot reproach any of the two states anymore for the difference. Sometimes that seems a bit surprising. For example, we have even a practical example where Germany says we apply our unlimited tax liability in inheritance tax law, first to all people living in Germany, and second also to people who left the country during the last 5 years before they die or give a gift to somebody else. The underlying idea of that 2.1 Erbschaftssteuergesetz Inheritance Tax Act is that otherwise people would always move abroad before they die or pass over their property. So it is necessary or regarded as necessary to close a loophole within the German law. Well, but this extended unlimited tax liability after you lived in Germany is now, surprise, only applied to people of German nationality. So if a foreign citizen was born in Germany, lived here all the time, and at the age of 70 leaves the country and moves to Spain, this extended unlimited tax liability will not be applied to him or her because that person is not a German national. So you see drastically different consequences combined directly with citizenship. Now that's a question, is this difference? Is that a discrimination on grounds of nationality or not? And the answer is surprisingly, one can at least question that, because you could also describe the situation as a consequence of to whom Germany applies its laws and to whom not. The idea Germany has is, well, we want to tax everybody in the maximum extent, as every state has. So we tax all the people who live here because these people have a connection to our state, and so under international law we can tax persons who have a connection with our state. When they live in our country, they have the connection. Now, if they have left, that's a problem. Under international law, we can tax everything. We can tax persons who have a connection with our state. And for example, you can extend or apply your laws to your own citizens who live abroad, but not to foreign citizens who live abroad. And you tax everything, can apply your laws to everything which happens in the inland or has an impact on the inland. So if somebody lives abroad and is a foreign citizen, you can, under international law, only tax what these people do in the inland. What is probably, at least under a conservative point of view, not possible, highly doubtful, is if Germany were willing to tax a Spanish citizen who lives in Spain with something what that person does in Spain or the rest of the world, because under international law, basic principles, we have no authority about the citizens of other states living abroad. So we could argue that Germany does only extend this extended unlimited tax liability to German citizens living abroad follows from compelling principles of international law. We would like to extend it to the Spaniards too, but we can't. So this would not be a discrimination, but just a consequence of which state applies its laws to which people. And one can say that as long as there is no common rule on EU level, let's say a double taxation treaty or a directive on who taxes whom under inheritance tax law, as long as such a central rule does not exist, every state is free to decide the scope of application of its own law, at least if that scope is not defined arbitrarily. And so one could say this is not discrimination. It just follows from the restrictions of international law. So that would probably pass criticism and would be regarded as, okay, a matter of the different competences of different states. So let's look to further things. Well, more negative treatment. Now let's vary the thing. State A takes a higher tax from a foreign. Oh, I did. Sorry, here. Treats an inland taxpayer more favorably. That must be more favorably. Sorry, I corrected immediately. So now I have changed it. So state A treats an inland taxpayer more favorably than a foreign taxpayer who also has to pay taxes to state A. And it shall absolutely be clear that there is no bad intention behind the difference. Now state A says, well, it can't be a discrimination, can it? Because we didn't want to do any harm. It just happened. Well, the answer is, naturally, that must be a discrimination. This can be no argument which you bring forward here. We had no bad intention because, think about it. First, the text of the law forbids discriminations, and nowhere says that a discrimination is only something which happened on purpose. If you want to protect people against harm, it should play no role if the harm is intended or not. We are not here in the area of criminal law. We want to protect people. Second, if forbidden discriminations are only the ones which a state did on purpose, that would render the whole rule useless in practice, because naturally a state, if it wants to discriminate a foreigner, is always able to cover up the whole thing and pretend that it happens without bad intentions, just based on a wrong view of the world or so, or on the reasons of simplification or so. So you would have no possibility to effectively forbid discriminations anymore. It would just become a voluntary, merely programmatic sentence, not an obligation. So it would violate the idea that EU rules are meant serious. So you would have no possibility to distinguish the intended discriminations from the just happening involuntary discriminations. So the only way out is that you regard both as forbidden, otherwise you can skip the whole thing. So intention, no bad intention, is no argument. Now imagine we have, again, the question, is there a negative treatment? State A says we tax our own citizens with 20%, foreigners we tax with 40%. Now, State A says, well, this is not really negative because, okay, the tax rate is higher for the foreigners, but the foreigners don't have to serve in our army with compulsory service. So, taken all together, it's a mixture of advantages and disadvantages for the foreigners. And in addition, by the way, they live in areas where the weather is better, so their life is far better below the line than of our citizens. So that justifies the 40%. Taken everything together, they are far better off. That is, by the way, evident from the fact that they still live in Spain. If they were better off in Germany, they would have come to Germany. So they can't complain. As you see again, if you allow this perspective, everything can be regarded as not negative enough. So the answer is such an argumentation, not to look to the tax rate alone, but also to involve the weather situation, the army, and something else, the better or worse education, or what else. Such an argumentation cannot be tolerated because you would always find additional differences where you can talk yourself out of the reproach of a discrimination. Well, so if you could always talk yourself out of more negative treatment if you draw the lines wide enough, the scope of what you take into consideration, then that can't be. Because otherwise, again, EU law would be turned, the anti-discrimination rules would be turned into useless, effectless provisions, and that can't be meant. So the only conclusion which you can reasonably draw is, when the debate is about the tax rate, the only arguments which can matter are the ones which are related to the topic tax rates. Everything else, which has nothing to do with the topic, must be excluded. That is sometimes called the principle of non-compensation in literature. It is not possible to compensate disadvantages which you inflict to a foreigner in one area of law by advantages which they obtain in other fields of law. So you have strictly to concentrate on the rule in question when you have a debate if that rule is a discrimination or not. You cannot mix everything together. So that's necessary because otherwise the whole rule turns into a shame. So in our concrete situation, the dispute about the tax rates, it would be clear you can only debate about the tax rates, and so it's clear if the foreigner has to pay 40% and the inland citizen only 20%, then it's clear that the foreigner is worse off. The weather situation, the army situation have nothing to do with the tax situation. They have to remain out of consideration. They cannot be an argument. Okay, so let's go to another case or constellation. Imagine now that state A demands a tax rate of 40% from foreigners because they are limited liability taxpayers. And for its own citizens, they have a range of progressive tax rates. It begins with 20%, it ends at 45%, depending on the people's personal wealth. Now, taxpayer X regards himself as treated less favorably than an inland taxpayer. State A says, well, 40%, okay, this is differently, but not necessarily negative, because it depends strongly on the personal situation. Okay, if you normally would pay 20% if you lived in our country, that would be negative for you. But there are also people who would have to pay 45%, and compared with them, you are better off. So some are treated negatively, others are treated favorably by the rule, and so our idea is it's not more negative. And the answer is here, okay, if you see it this way, you could again treat many persons less favorably than your own citizens, just if you leave a small range for some people who are then better off than the inland comparable people. And so, again, you could render EU law widely useless. So this cannot be accepted. You could otherwise make all rules which make differences immune against critique from EU law if you take care that at least 1, 2, or 3 cases are preferable or more favorable for the foreigners, and all the rest could then no longer be criticized. Look at my rule. For example, okay, only the top people, those who would have to pay 45%, have an advantage, because as foreigners you only pay 40%. All the average citizens and below have a strong disadvantage, 40% instead of 20, 30, 35. So that can't be accepted. So again, the situation would be solved by the non-compensation principle. It is not possible to compensate the disadvantages inflicted to one taxpayer or to one foreign person by the advantages which are given to others. If I breach or harm your basic rights, I cannot say, well, if I add it up with the treatment which somebody else gets, in the average, it doesn't matter. Well, for you, it still matters because you are considerably worse off. It will not be a consolation for you if I even treat somebody else better than deserved. So it would render basic rights useless if you allow a compensation between one is treated worse, but, well, somebody else is treated better. That's not a justification. So an anti-discrimination rule is meant to protect the individual single person, so the judgment, if a discrimination is given, happens on the level of the individual case. So you can't talk yourself out of problems in that regard by pointing out that there are other cases where there is not a more negative treatment. Okay. Well, so we have understood again another piece of the logic behind that discrimination jurisdiction. Negative treatment. Well, now let's look a bit to the particularities or peculiarities, to the details. Imagine taxpayer A can offset expenses for a life insurance as special expenses, or you might translate it special personal allowances from the tax base, from the taxable income in state A. When it comes to taxpayer B, who is a national of a different country, state A does not allow this deduction. Now B sees himself or herself as discriminated. A can something deduct, I can't. Well, now what you need to know additionally is that under the rules of state A, taxpayer A will later have to pay taxes on the revenue from the life insurance, whereas taxpayer B will get off the thing completely tax-free. So B cannot claim the expenses, but will not have to pay for the revenue. And it shall also be undisputed that if you add both together, that then the advantage is on the side of taxpayer B. Now taxpayer B says, well, there is a non-compensation principle. Every rule has to be seen in itself, isolated, and there is one rule about the expenses, and there is another rule about the taxability of the revenues from a life insurance, so you can't mix two rules together. You have to stick in the debate to the one rule, the rule which about the expenses. Now, is this an argumentation which you would accept? And the answer is, I would not. Why? The principle of non-discrimination, non-compensation naturally applies here. But if you see, well, the expenses and the revenues are treated alike. Everybody who has an idea of income taxation knows that this seems to be a kind of underlying principle of income taxation everywhere. And just to argue that the rule which is in play must be seen in a merely formal way. The rule about the expenses is in, let's say, section 4.4, and the rule about the revenue is somewhere in, I don't know, paragraph 22. This cannot decide about the matter. You cannot define the scope of investigation just depending on merely formal aspects. When it comes to decide what is the rule where we talk about, then that must be a matter of contents. What does this rule really consist of, and not where is it written? One and the same rule must be judged under a contents perspective. So what actually forms one and the same rule, what always applies together, a set of different sentences is, wherever it is written, one and the same rule if it only occurs together. So if it cannot be separated in the real world, then it's one single rule. You cannot isolate only the treatment of expenses, in my case, without ignoring the consequences for the revenue side, because as expense and revenue are always treated together according to the same principles, this forms materially only one rule, one single rule. So every part of the rule can be taken into consideration when you debate about things. So in our example, the expense is always connected with the later treatment of the revenue. So treatment of expense and revenue for one single rule. And so both can be brought into the discussion. And if you see that together, you will indeed find the taxpayer B does not suffer a negative treatment. Now, another example. If a foreigner has to suffer less favorable treatment of wages, but gets treated enormously better in the area of interest income, is that the same rule or not? Let's say both is limited tax liability rules. Now, can you justify or talk away the negative aspects of wage taxation with the positive aspects in the area of interest? Then there is a simple question. Is it possible that cases arise where somebody has wages but no interest? And the answer is yes. Is it possible that people arise who have interest income but no wage income? Yes. So the two parts of the law are not internally dependent on each other. They can occur separately. So these two rules are different rules. So what is not connected in 100% of the cases but can occur separately, these are separate rules. That principle that you have to define the contents of a rule and the range of a rule according to the contents and what really belongs together, not to formal aspect. That is also called in literature and even jurisdiction the principle of coherence. The states have a right that their rules, wherever, in which area of law ever, can and shall be examined entirely as an entity, as a coherent entity. So you are not allowed to artificially separate what belongs together in all cases. By the way, you will often find some court cases where the fiscal administration, after they had heard that the coherence of rules had to be accepted, just always brought forward in court, well, our whole tax system is a coherent entity. It can only be either applied together as a complete set of rules or not. That is laughable because they didn't understand the logic. They just had the idea, oh, we don't understand EU law. We have heard coherence of a rule might be an argument which they accept, so we just speak about coherence of rules. Naturally, if you say, well, limited tax liability forms one coherent rule, that's simply impossible. There are cases where somebody has income from a house and somebody has income from a wage, and this does not always show up together, so this is definitively two different rules. And that's it. So if you ever begin, or when, better, because it should be certain that at a certain time you begin to read court decisions of the ECJ, when you read there that a state brings forward, well, this is a coherent rule, you should always check if they are right, because, well, a lawyer in court, they do not explicitly lie, but they express rather strange opinions. Let's draw the line this way. If the strange opinion is in favor of their people. So you should not believe everything what's said there, but concentrate on how the court then reacts to such an argument. Good. So principle of coherence is something which you must keep in mind. What is materially, what is actually one rule has to be examined together. What can happen in separate cases separately is two rules. So one rule is then excluded. Well, discrimination must be a discrimination of a person protected by the rule. So if the freedom of establishment is granted to a French citizen, then the French citizen is protected. So only inflicting negative treatment to the French citizen would be forbidden. Now, under which circumstances are you discriminated? Imagine that the French citizen has the right to come to Germany and open up an enterprise here. Now we grant that citizen non-discrimination, but the treaty is silent on the family members. So the spouse and the children are brutally beaten up by everyone in the street every day. And whenever they go to the police tells them, well, you are not people who exercise their freedom of establishment. You have no rights. Protected is the person who exercised freedom of establishment. That is, let's say, your husband. And we always treated your husband in the best possible way. Only you and the children were beaten up and treated arbitrarily and discriminated everywhere where we could. Now imagine what remains from the freedom of establishment if you are a foreigner, want to open up an enterprise here, and no, you can come here, you will be untouched, but your family will live in hell. And that would entail that in reality you would not have the possibility to come here. So it is regarded as a necessary reflex of a non-discrimination rule that if a person makes use of its rights under the treaty, also the family members must have a protection which is a reflex of that right of that other citizen. So the family members also are protected against any discrimination on grounds of the citizenship. Well, what is if the family members have not the citizenship of an EU state? And the answer is, well, protected is, let's say, the French citizen who opens up an enterprise here, and the family members who live together with him or her are protected as a reflex of the protection of the French. So the reflex protection for the family members does not ask for their citizenship. French citizens can come here unharmed. That includes no harm for the family members. And, well, every French citizen has that right. Now, even those French citizens who happen to marry the wrong spouses, those without EU citizenship. Nowhere in the treaty is a rule which says French citizens have rights, but only if they marry the people whom we like. Well, that's nowhere there. And so the courts have always held, if a foreign EU citizen is protected, then the family members who live together with that person and are dependent on it, on him or her, better than it, then they are also necessarily protected, because otherwise the protection for the French citizen, the non-discrimination of the French person, could be rendered effectively or actually useless in real life. You can't afford to come here for a job or to open up an enterprise if your family is going to live in hell here for the next 30 years. And very often you can't afford to come here if you have to leave your family at home. Most people don't marry with the intention not to see their partner for the rest of their lives, only apart from 2 days a year or so. So naturally, there must be also a protection of the spouses and the family members. Well, you could even vary this principle because there is now a legal problem. Spouse of taxpayer A is discriminated, and now the matter goes to court and the national courts as well. In a court, people can only complain if they have been harmed. You cannot complain about the matter which doesn't affect you. Now, taxpayer A is protected by the freedom of establishment, but taxpayer A suffered no harm, discriminated was the spouse. Now, when the spouse comes and raises a claim in court, the court says, well, congratulations, you were really harmed, but you are not protected under the treaty, so you have no claims to make. So we dismiss your lawsuit too as inadmissible. You have no own rights. That really has happened from time to time, and then the matter went to the European Court of Justice. And naturally, what did the court decide? They said, okay, if we allow this game here, then it would be possible to harm the family members, and due to formal reasons, you could never end that, because you would never be protected by a court. So necessarily, it follows from the principle that also the family members are protected, that the family members can invoke these rights themselves in court in their own favor. The state is obliged to protect or to uphold the non-discrimination principle, and that necessarily implies that also a right must be given to these family members to invoke these rights in court and to raise claims in their own interest. So these people have own rights. The same applies, by the way, if the person protected by the rule and the family members are not discriminated, but people who do business with them. There have been cases where, for example, a state said, okay, we allow the deduction, let's say, of interest expense as business expenses, but only if these interest payments are made to people in our own country, not if the interest payments are made to customers or to creditors abroad. Is this discrimination of foreign customers? Yes. Or foreign business partners? Yes. And can the bank invoke own rights to protest against this treatment? Here we have again the same thing. Discriminated is business with foreigners, but the foreign customers themselves are not harmed, but only the people who do business with them are inflicted a harm. And naturally, that must also be forbidden. It's one of the oldest tricks to avoid or circumvent a non-discrimination principle. Well, don't touch the protected person, but beat up everyone who deals with them and makes business or has contacts with them. That must be forbidden necessarily, and that can only be effectively forbidden if these people have the right to raise own claims in court. So necessarily the bank can protest and say, we claim that the business expenses made to foreign customers are declared deductible. We do not need to motivate the foreign customers to start a lawsuit. We can start a lawsuit in our own right, because what happens here is a discrimination of the foreigners, and everybody to whom harm is inflicted on that grounds can raise a claim in court. Otherwise, the rule could be rendered useless again in practice. Okay. Now let's turn to the next criterion, comparable circumstances, ladies and gentlemen. And, well, imagine state A applies different rules for the determination of a depreciation for a house which taxpayer A lets to tenants and owns in the inland. And there is also a house which taxpayer B living abroad owns in the inland and rents to tenants. Now, is the determination of different percentages for the depreciation, is that a discrimination or not? Is it comparable circumstances? Now, state A says, well, the situation is not comparable. Taxpayer A is unlimited tax liable. Taxpayer B is limited tax liable. Well, would you accept that? And the answer is, well, rather not. Because if you can bring forward any difference which exists in the field of taxation as an argument that the situation is not the same, then you will always be able to find or create such a difference. So you can always talk yourself out of reproaches. So the logical conclusion is you cannot tolerate that. You can only accept circumstances in the comparison which are relevant for the matter which is in question here. And so you have to look what is relevant here. And two people let a house to tenants. The house is in both cases in the inland, and both have to pay taxes on it, and everything else seems to be comparable. With regard to that part of the income, everything seems to be identical, and one can simply see no reason why the depreciation, so the loss in value of the one house, should be higher than that of the other house. Limited and unlimited liability just are about which other sources of income will add it to that income. But I can see, and nobody else will be able to see, a reason why the question, how much do you earn from that individual house in the inland, should be different depending on who is the owner. That is not plausible. So all the rest should be left out of consideration. This has evidently nothing to do with the matter in question. So you would have to leave out again everything which is not combined, which is not relevant for the situation, for the matter which has to be regulated here, the determination of how high is the income from the house. Everything else can occur in addition or not, so it's evidently a different topic. Yeah. Comparable circumstances. It might be that both have a residence in state A and both have a residence in state B. And now under the double taxation treaties, the treaty residence, Article 4, is in state A for taxpayer A and in state B for taxpayer B. And now A gets a certain deduction and B not. The different situation under the double taxation treaty could lead to different circumstances which matter for the case. For example, if the deduction is usually granted by with regard to the fact that we tax the worldwide income, then if A is resident in our state, we usually can tax A's worldwide income with a few exceptions. So it would be fitting to grant A that deduction. On the other hand, if B is resident in state B, we, state A, can only tax some small items derived from our state from the worldwide income of B, and the whole rest of the worldwide income of B will go to state B. So here the situation, if the worldwide income really matters, then the situation would probably, due to the different DTT situation, different. So the situation in a double taxation treaty can always make a difference if that DTT really affects the possibilities of taxation of the states in question. Otherwise, probably not. Okay, let's go on. And well, on grounds of nationality, naturally also poses some questions. For example, taxpayer A lives in state A, taxpayer B lives in state B and has, however, nevertheless, also income from state A. Now state A takes a rate of 30% from taxpayer A and 50% from taxpayer B. And now state A brings forward that this does not happen on grounds on nationality, because the one taxpayer is taxed under the rules of unlimited tax liability, whereas the other is taxed under limited tax liability. And these two things are automatically different and they have nothing to do with nationality. Now, do we have here a discrimination on grounds of nationality or not? And the answer is yes, we have. At least the suspicion is justified because the distinction does not officially look for differences in citizenship. And there might even be some rare citizens of state A which live in state B, are therefore taxed under the rules of limited tax liability and are also hit by the higher tax rate. But what you cannot deny is that it remains a fact that most of the taxpayers who live in the inland will be citizens of state A. And most of the taxpayers who live in state B will be citizens of state B. So the distinction where these people live mostly has the same result in most cases as the distinction according to the nationality. So if you were to allow a state to deliberately, freely, and completely uncontrolled distinguish between where people live and then pretend to say this has nothing to do with nationality, if you were to allow that, you would, in practice, allow a state to discriminate against foreigners according to their wishes as ever they want to, and you would give up every chance of controlling that. So the only convincing solution here is to say, okay, yes, this is mostly equal to a discrimination on grounds of nationality. You formally and officially use a different criterion, but it mostly leads to the same result, so it's virtually the same. So yes, this would be called a covert or indirect discrimination, where you use a different criterion, but which in the final effect leads to mostly the same result. So yes, it would be a discrimination on grounds of nationality, although you do not use the word. Sometimes it's hard to find out, especially the more you are an expert, the more you have been used to the traditional ways to see things. Sometimes it's really hard to recognize or to realize that a certain rule is virtually a distinction according to nationality. In former years, for example, some 20 years ago or so, Germany demanded an add back in trade tax matters only in case of rent payments if the recipient was not subjected with that payment to trade tax. Now, the question is, could you see here an indirect discrimination on grounds of nationality? The idea was evidently, if a rent payment is made to a person who is not subject to trade tax, then this money is lost from the trade tax base forever, and so we want to avoid that. So if a firm pays to, let's say, a private person, this shall be added back. Well, could this be seen as an indirect discrimination on grounds of nationality? And the answer of the courts was certainly yes. Because if you look to a rent payment which is made to another firm in Germany, the other firm will automatically be subject with that revenue to trade tax. On the other hand, if you pay such a payment to any other firm in Europe, the other firms will not be subjected with the revenue to trade tax. It might be that they have a kind of a corresponding tax at home, but this will not be German trade tax. And it might even be that they don't have a local tax, but that their corporation tax is higher. So we would say they are not subjected to a parallel tax, parallel structure to the German trade tax, but in their state's tax system, well, they would pay a considerably or comparable amount of tax. So there is no reason to make a distinction. And well, what remains in the end is, well, if they are a German firm, they pay trade tax, German trade tax. If not, then not. So this is a hidden discrimination, a covered or indirect discrimination on grounds of nationality, and the answer is yes. So this would qualify for a test. Without justification, the last step. Well, if you can check and can say, yes, fulfilled all the first three criteria, then you still have to check if the discrimination can or cannot be justified. So if the treaty allows it or not, and certain discriminations may explicitly be allowed by the EU treaties under circumstances laid down there, and therefore might form a legal justification. For example, you remember the case, the small little rule that no state is forced to allow the application for a job in as a state official exerting state authority, that they are not forced to open these jobs to foreign applicants. So, head of the German military, we do not need to take into account the job applications of, let's say, a Spanish general. We can reserve these positions for our own citizens. So that would be an explicit exception from the non-discrimination principle there. However, the courts have always held that such exceptions, as they are exceptions from rights which are conceived as fundamental rights, have to be interpreted in a narrow sense. It shall not be tolerated that a written exception is interpreted in a so wide way that virtually nothing remains from the underlying basic right or basic rule. And so the idea is always exceptions have to be interpreted in a narrow, I might even say in a mean way, so that the exception is only applied in rare cases. So where it is only where it is explicitly stated, and in a strict, narrow sense. Explicit exceptions can be found at different locations in the treaties. So here's a bit of a homework for you. Take a printout or take an online version of the Treaty on the Functioning of the European Union. Have a look on the parts of the text which deal with the fundamental freedoms, and have a look where you find explicit exceptions from these freedoms. Okay, now There are also implicit justifications. You remember that idea, for example, which I told you in the last video, when it comes to explicit, or no, when it comes to restrictions, that there is also the possibility that there are certain restrictions which are tolerated silently by the treaty because these measures are regarded as necessary, because otherwise the whole world would break down. Remember that case where the Italian or from wherever professional killer comes to Germany and kills somebody on order of somebody who pays for that. That would be cross-border rendering of services. So that would be the exertion of the freedom of services, and so arresting that person would be forbidden, because it would be a measure which makes exertion of that professional's cross-border business activities less attractive or even hinders it. Now, jurisdiction says no, that would be the wrong approach. We must allow the states here to still apply their criminal law, although it has a restricting effect on cross-border activities in certain areas, because otherwise the whole civilization would break down. So now you have also, no surprise, certain discriminations which are implicitly tolerated by the treaty, because one could argue that the rules must be upheld in the way which they are, because otherwise we would end up with completely unbearable consequences for the legal system of a state. Or it might be that equal treatment would even be not technically possible. So that the positive treatment which an inland person gets could, for technical reasons, just not be extended to a parallel person or a person in a parallel situation abroad. So one might assume, okay, certain discrimination or certain cases where equal treatment might be needed will be nevertheless tolerated by the treaties. And now the question then is naturally, what can qualify as such an unwritten justification, as a reason to tolerate a discrimination? This is always a question to the European Court of Justice. What is the right interpretation of the fundamental freedoms? Which reasons do they silently tolerate, and under which circumstances can one still uphold the idea that this reason nowadays still is a convincing and compelling reason? So the question is, or the principle here is, well, all that will have to go to court. And so you have a mass of court decisions in that area, either with regard to taxation or to other parts of law, other fields of law. So the arguments there which have been brought forward and accepted or rejected allow conclusions how the court would decide in similar cases which have to do with taxation. Certain justifications, nevertheless, might be shortly discussed. For example, one of the most frequent ideas is a state says, yeah, we would like to abolish the discrimination, but we can't, it's too expensive. Well, if you tolerate the money argument, then you could say you have to tolerate everything, because if you discriminate somebody on the field of taxation, then you only do it because it brings money. So an abolishment of the taxation of the discrimination naturally would reduce your taxes. This would be an argument by which you could justify everything, and so it would lead again to the complete downfall of the whole effect of the fundamental freedoms. So this argument can never be tolerated. By the way, you could always avoid the decrease of your revenue just by replacing the existing rule by a fair treatment which collects a certain amount, an equal amount of money from both persons or categories of persons involved. So increase the tax burden of the one a bit, reduce the tax burden of the other person a bit, and then let's meet in the middle. That is always a possibility. And so The fiscal consequences cannot be a justification. Well, now a state might also say, oh, we would like to help, but well, the EU has no right to harmonize direct taxation there, or they have a right to harmonize direct taxation, but there is as yet no EU harmonizing directive, so everybody of us still has to do things on its own, and we can choose our tax rules freely. And well, so sorry, there's no rule. And the answer is wrong argument. There is a rule. Under EU law, the basic principle is that member states can do whatever they want as long as they do not violate rules of EU law. The rule of EU law is, well, we have not made a rule on the tax system, so you can do whatever you want. But there is one limit. What is explicitly forbidden is discrimination. So you can choose any tax rule you want as long as you want, and as long as it does not contain the forbidden discrimination. If there is a forbidden discrimination, you have to cancel it, and you can then freely choose again the replacement rule as long as it's free of discrimination. So we do not interfere with your tax law. You can freely choose whatever you want, but you have to keep it free of discrimination. And that is the only point which we, the judges, will check. Further ideas have very often brought forward and then dismissed in standing jurisdiction by the ECJ. For example, things like, well, we think this is a matter which must be solved in bilateral negotiations, in double taxation treaties. This can't be done on our own. And the answer is yes, it can and has to be done on your own, alone, without bilateral negotiations, because the order, your tax system must be completely free of discriminations, is already a concrete and binding rule which everybody in Europe has to accept and follow. So you can't say, well, there is a binding rule, but we first have to negotiate about it still. No, you have to stick to it. So you have to obey. You can do whatever you want, but only as long as you don't discriminate. So there have been many, many arguments which the fiscal administration brought forward and tried to get this accepted as a justification by the ECJ. Many arguments have been rejected, even several times often. So there is a standing jurisdiction on what is possible and what not. So please have a look to the court decisions from time to time. You find them at curia.eu, and usually you do not find them under the chapter taxation, because what is explained by the court is not tax rules but the fundamental freedoms. So you will find the respective jurisdiction under the headline freedom of establishment, freedom of workers, freedom of movement, and all that, not under taxation. And yeah, another important thing is there are even ways how you can disprove the argumentation of a state that a certain discrimination is necessary and can't be abolished, so that because otherwise the whole world breaks down. And so this is important, that you have possibilities. If you can find at least one situation where the circumstances are completely identical to the one in which your taxpayer is, but the person who is in that situation, the comparable person, is treated better than your taxpayer, then by the existence of that absolutely identical situation where somebody else is treated better, the state in question automatically admits that the strict treatment which your taxpayer gets or your discriminated person gets is not necessary for keeping up its legal system. If you say it's absolutely necessary to do something and then renounce on doing this in an exactly comparable case somewhere else, then there can be no justification, because then evidently your legal system doesn't break down when you renounce on it, because proof you are able to renounce on it in the case of somebody else. The important thing there is that you need, for comparison, to generate and examine a situation which is really exactly comparable. So you need a situation where the only thing which is the difference is the nationality of the person involved and all the things which are, let's say, identical or mostly identical criteria. So in the field of taxation, that would mean you look to two taxpayers having exactly the same amounts of income from exactly the same sources at exactly the same places, not at corresponding places, at exactly the same places. So when you look to a German taxpayer who has income from a house, or when you look to, let's say, a Belgian taxpayer who has income from a house in Cologne, 10,000 euro, you compare that taxpayer with a German taxpayer who has income from also a house in Cologne, being exactly 10,000, and then you look for differences. And if this taxpayer of yours, the Belgian guy, has then also a job income of 20,000 from Belgium, you compare that Belgian person with a German who has income from a house in Germany and, now surprise, has job income of 20,000 from Belgium at the same places. And then, if everything by definition is equal, apart from the residence and the nationality, then you compare the tax treatment. And if even the DTT situation is the same, for example, in my case of my German taxpayer, the job income exists also in Belgium. And if the DTT says, okay, you are unlimited tax liable, but Belgium gets the money and Germany exempts, then you can see, okay, in both cases, Germany can tax 10,000, and in both cases, abroad, there is an additional income of 20,000. So exactly the same things happen at exactly the same places. And it's only the nationality which then causes a difference in how we treat that situation. Well, this is a way how you can define comparable situations. And then you can show there can be no other difference in the situation which could be relevant. And if there can be no relevant difference in the circumstances, there can be no reason to make a difference. Because if there is no difference, absolutely no relevant difference in what happens, there can be absolutely no reason to react differently. And so that explains why, with that principle, you can easily show the argumentation of a state, this is necessary for our system, as what it is, an error or a mere pretext. And that is where you always have to focus on if you want to debate about discrimination or not. Take greatest care that you examine an exactly comparable situation where everything is absolutely identical apart from the nationality. And if you can find these situations, and then you see this comparable constellation is treated differently, then you have a formal proof that evidently here something is treated differently only on grounds of nationality. And then you have very good cards to win in court. But then you have to explain that in a way that everybody can see that. And you have to avoid that others try to bring in some other cases into the discussion which are not comparable with the situation about which you talk, which might be a good strategy for the fiscal administration to confuse the situation and to make the comparisons rather nebulous and bring uncomparable other situations to the front so that people are confused. So your task would be to make things as clear as you can. Okay, that shall be enough for our discussion now about the topic, what is a discrimination? And we will naturally also have to talk about what is a restriction, and you probably can already suppose what's going to come in the next video. So thank you very much for watching again. It was nice to talk to you. Hope you come back soon and come back for the next video. Thanks for watching. Goodbye. Enjoy the days till we come back. And yeah, that's it for today.